So good morning and welcome to the West Australian Local Government Association and the Department of Mines Industry Regulation and Safety webinar on the Industrial Relations Legislation Amendment Act 2021. My name is Sam Lyon and I'm the Employee Relations Project Consultant in the WELGA team. I've also got Kara Bruder, Director of Private Sector Labour Relations, with me today, who will be presenting next, and Davina Hunter, the WELGA ER Services Manager, who will be joining Kara in a panel discussion. Today's webinar will be recorded and will be available on our website via the ER Services link. Before commencing the formal part of the presentation, I would like to acknowledge the many traditional owners of the land on which we work throughout Western Australia. We pay our respects to their elders past and present. In respect of the presentation today, the following webinar is intended to be industrial relations information only and does not constitute legal advice. For ER service subscribers, you're welcome to get in contact with us, as we may be able to provide additional information to you or alternatively advise of panel services to get additional information. In terms of the webinar today, I will be going through some background information and the impacts for local government. I'll also briefly take you through changes to the Industrial Relations Act, the Minimum Conditions of Employment Act, and the Public Bank Holidays Act, with a focus on local government. I'll then hand over to Kara, who will give us an update on the regulation process and also provides any updates on the federal declaration about whether that may or may not be endorsed anytime soon. Kara will then also move on to advising us about the relevant day, the meaning of that, and also how the legislation may commence in terms of moving local governments to the state industrial relation system. She'll also work through transitional arrangements with us and a series of case studies to help us understand what will happen when federal industrial instruments move into the state system. Following that, Kara will provide a brief overview of the state award system, and then Kara and Davina will join together and we'll have a series of panel questions and discussions before we close. If you would like to ask a question during the webinar, please use the Q&A function, and this can occur in the lead up to the panel discussion session or whilst the panel discussion session is occurring. If we don't get to all of the questions that have been asked by local governments today, we will be contacting you following the webinar and try and assist as much as we can. Just to provide a brief overview in terms of the amendments and how things have occurred. So the background to the changes to state legislation and the amendments to the state legislation occurred as a result of two reviews. In 2017, a ministerial review was conducted of the state industrial relations system. And in 2019, there was an inquiry into wage theft in WA. The ministerial review in particular focused on whether local government employers and employees in WA should be regulated by the state IR system, and if so, how the outcome could be best achieved. Those two reviews then fed into the creation of the Industrial Relations Legislation Amendment Bill 2020. That bill, although it was passed, or it was put into state parliament, it didn't pass in December 2022. And then the Industrial Relations Legislation Amendment Bill 2021 was introduced. That has since received royal assent on the 22nd of December 2021 and became the Industrial Relations Legislation Amendment Act 2021. Now, as far as that legislation is concerned, Part 1, which deals with the title and preliminary matters, commenced on the 22nd of December 2021. However, the other parts of that Act have not yet commenced and they will be proclaimed by the Governor. Just in terms of the amendments to state legislation, for local governments, there are 3 key pieces of legislation that are applicable. So the Industrial Relations Act, the Minimum Conditions of Employment Act, and the Public and Bank Holidays Act. There were also amendments made to long service leave legislation. However, these aren't applicable because the regulations govern long service leave in the local government industries. If we have a look at the industrial relations changes, I guess the key for local governments is the declaration of local governments to not be national system employers, which has been put into the Industrial Relations Act. And the IR Act effectively acts as a mechanism to declare various local governments, or all local governments, to be not national system employers for the purpose of the Fair Work Act. Although that occurs, there's still the requirement for regulations to be drafted and then for the Federal Minister of Industrial Relations to sign off or endorse that declaration. The other key changes to the Industrial Relations Act were or are increasing the coverage or scope of the definition of employee to include domestic workers, providing the Western Australian Industrial Relations Commission to vary award scope for private sector awards on its own motion, changing record keeping requirements, introducing a stop bullying and sexual harassment jurisdiction in addition to an equal remuneration jurisdiction, and placing prohibitions on employers, for example, like sham contracting. There's also been amendments to the powers and penalties for industrial inspectors, providing them with additional powers and also higher penalties for employers. As far as the changes to the Minimum Conditions of Employment Act, there has been an introduction of 5 days of unpaid family and domestic violence leave into the minimum conditions. And in addition, there's been a modernisation of paid sick leave and carers leave provisions and changes to supported wage, which requires the WARC to make a determination as part of the state wage case in relation to the supported wage system. The final amendment applicable is in relation to the Public and Bank Holidays Act, whereby there's a new public holiday across Western Australia that's been introduced, and that is Easter Sunday. So what does this mean for local government? At the moment, we've got a situation where local governments are operating across 2 different jurisdictions, the federal system and the state system. As far as the laws and the amendments are concerned at this point in time, those local governments operating in the federal industrial relations system will need to make changes to their workforce to accommodate the new public holiday. As far as the other amendments which I discussed today, those changes will be applicable and become a requirement if local governments transition into the state industrial relations system. As far as local governments operating in the state system, as soon as the governor proclaims the remaining parts of the Act, then local governments in the state system will have an obligation to comply with those laws. I'll now hand over to Cara, who will take you through some of the more technical details of the legislation.
Good morning, everyone in remote world. The technology works. So I'm just going to take you through some more of the detail of the amendments. So as Sam said, the Act has been proclaimed. The Act has been enacted. So we are now drafting regulations to support the commencement of the rest of the Act. We anticipate that will probably take between 6 to 8 weeks, although there are a few contingencies there. And once that's happened, then the rest of the Act will commence. There is part of the Act which relates to the new Easter Sunday public holiday. Those provisions are expected to come into effect in the next few weeks. So they have to be published in the Government Gazette. And once that occurs, an Easter Sunday for 2022 will be a public holiday. So the local government provisions of the Act, as I said, require regulations to be drafted. There will be two separate sets of regulations. The first set will declare every West Australian local government to not be a national system employer for the purposes of the Fair Work Act. And the second set of regulations will fix the relevant day. So the relevant day is in effect the day that the declaration commences, that local governments are not national system employers. And so for all intents and purposes, the relevant day is the day that local governments will move to the state industrial relations system. The relevant day cannot be set yet because the government is still in discussions with the Federal Minister for Industrial Relations, Michaelia Cash, about whether or not the federal government will endorse a declaration made by the state. So in other words, the federal government's support is required in order for this to occur. And as I said, those discussions have been ongoing for some time. In terms of the provisions of the Act, it sets out transitional provisions to move local governments from the national to the state system. And in effect, if you have an enterprise agreement or a modern award that applies to your workforce, that instrument will become a new state instrument in the state system, and effectively it will become an industrial agreement. So industrial agreements are the collective form of bargaining agreements in the state system. That instrument will have a nominal expiry date of the earlier of 2 years from the relevant day when you move into the state system, or the nominal expiry date of the instrument itself, whichever is the earlier. So if you have an enterprise agreement that's already passed its nominal expiry date, for example, when it moves into the state system, then that remains the nominal expiry date. It won't be the 2 years. As modern awards don't have nominal expiry dates, they will be subject to the 2-year maximum nominal expiry period. While the nominal expiry date of the new instrument may pass, it doesn't mean there's a drop dead date. It's not an automatic drop dead date. Because the instrument becomes an industrial agreement under the Industrial Relations Act, it will continue in effect beyond its nominal expiry date. So in the state system, there is a different process for ending instruments which have passed the nominal expiry date compared to the Fair Work Act. It's quite a simple process. So in the state system, a party to the agreement can give notice to the registrar of the State Commission that it wishes to retire from the agreement. And at the end of the 30 days notice period, the agreement will come to an end. Now, in terms of when notice can be given, it can be given 30 days before the nominal expiry of an agreement or any time after the nominal expiry. So it's pretty much an automatic process. There is no requirement for the Fair Work Commission to assess that application. There's no need for an argument to be made about whether it's in the public interest to terminate. The agreement will simply come to an end. At the end of the retirement process, if there's no new agreement in place, then employees may fall to a relevant award, and that will depend on whether an award covers types of work that they're doing. In terms of the interaction with the new state instruments, they'll be subject to the Minimum Conditions of Employment Act, which is the equivalent of the National Employment Standards under the Fair Work Act, although there are some differences between the two. An employer, an employee or an organisation may apply to the State Commission to vary a new state instrument, and the Commission will have the discretion whether or not to make that variation, and has to be satisfied that it would be fair and reasonable to do so in the circumstances. If your federal instrument, which has come across, has got a reference to a federal union, then that reference will be taken to be the equivalent state union of which that union, the federal union, is a federal counterpart. So if you've got the ASU named, for example, in your federal instrument, will be taken to be a reference to the ASU WA branch. So now we have some case studies, and we've got here the Shire of West Australia, and it's got an enterprise agreement which applies to its outside workforce, and its inside workforce is also covered by an enterprise agreement, but one of the agreements has passed its normal expiry and the other hasn't. So the question is, will these federal instruments transition to the state system on the relevant day? So for the enterprise agreement that's passed its nominal expiry date, yes, it will transfer into the state system. It will become an industrial agreement from the relevant day, and its nominal expiry date will be the date of the agreement. So the agreement's terms will have effect. So it's already past its nominal expiry. That will remain the case in the state system, and it will have effect according to the agreement's terms. If for the enterprise agreement that has not passed its nominal expiry date, it will again transfer to the state system as an industrial agreement, and it will run its course to the end of its nominal expiry date or 2 years, whichever is earlier from the relevant day. So the maximum period will be 2 years. So other questions are whether the agreements are read as standalone instruments, or whether they'll be subject to Minimum Conditions of Employment Act. As I mentioned, they will be subject to the Minimum Conditions of Employment Act. That Act implies all the minimum conditions into state instruments, and a provision of a state instrument which is less favourable than a minimum condition of employment will be of no effect. So if your instrument implies the terms of the National Employment Standards, it will be necessary to undertake a comparison effectively between the National Employment Standards and the Conditions of Employment Act. So parental leave is an example where there are differences between the two, and while the federal parental leave provisions do extend to the state system as well, there are some subtle differences. For example, in the state system, there's basically a right to request flexible working arrangements, modified working arrangements once parental leave is finished. And this is an enforceable entitlement in the state system, whereas it may not be in the federal system. In terms of how long the agreements will continue to apply, as mentioned, there's nominal expiry dates, but they will continue to apply beyond their nominal expiry, and it's really a process of making a replacement agreement or one party seeking to retire from the agreement. So while the language of the Industrial Relations Act is retire, the effect of retirement is to effectively terminate the agreement. And can these enterprise agreements be replaced? If yes, how soon and by what process? So the short answer is yes, they can be replaced. They can be replaced at any time because the Industrial Relations Act does not prevent negotiation during the term of an agreement. So it's a fairly simple process. It allows for replacement of an agreement by a subsequent agreement. And there's a fairly simple registration process for agreements in the state system. It's nowhere near as detailed as the federal system. There are no voting requirements, etc., for employees or notification periods, but that's because the agreements are made with the union rather than the workforce. So hopefully I'm not running too quickly through these. I think I've answered that one and that one, sorry. So yeah, in that slide, I've just mentioned which sections of the Act you can refer to if you want to look at the registration process and what requirements must be included in your agreement for registration, and that's sections 41 and 41A of the Industrial Relations Act. Now we have a second case study. So this is the City of Citrus, which has its workforce on currently the Modern Award, the Local Government Industry Award, and then it has some employees who are award free. So we have a couple of questions there. What happens to the Modern Award when it transitions? And again, does the award read as a standalone instrument, or is it subject to the Minimum Conditions of Employment Act? So for award-free employees, they may be covered by a state award upon moving to the state system. and that will depend again on what they do. So in the state system, there are two main local government awards. There's the Local Government Officers WA Award and the Municipal Employees WA Award. And I've just put a reference there where you can get the full text of those awards, and I believe that will be on the WellGov website also. The Officers Award applies to salaried officers in a range of listed occupations, which are professional, clerical and administrative. And the Municipal Award applies to employees in a range of occupations, which might be considered more outside workforce occupations, including construction, maintenance, horticulture, transport, cleaning and security and the like. So if an employee is not picked up by one of these awards, they may be covered by another state award, so it will depend again on what they do. And to give an example, if they're an employee in a cafe, they may be covered by the Restaurant, Tea Room and Catering Workers Award, which has quite broad scope. State awards operate in the state system by common rule, which means they extend to broad industries and broad classifications, and it's necessary to check the scope clause of the award. And they can be quite confusing sometimes, the scope clauses, not necessarily as clear as the modern awards, but the amendments that we're making to the Industrial Relations Act will be directed at trying to clear up the scope clauses of private sector awards so they are clear and they are industry based. If an employee has no award coverage, then they'll be simply covered by the Minimum Conditions of Employment Act and of course any contractual arrangements that might apply. I might have skipped. Sorry, I'm going to go backwards just to go back to, there you go. What happens to the modern award when it comes across? Once again, a modern award will become an industrial agreement under the Industrial Relations Act. So it will be the same as the enterprise agreements. They will all become industrial agreements, which provide simplicity and consistency in the rules. And again, because modern awards don't have a nominal expiry date, the maximum 2-year period will apply to modern awards. At the end of the 2-year period, as with any industrial agreement which has passed its normal expiry, one of the parties may retire from it by giving the notice, or you can do a replacement agreement. And as mentioned earlier, a replacement agreement can be negotiated any time during those 2 years. Moving forward, apologies. Just got a slide there which includes some resources from the Department of Mines, Industry Regulation and Safety. So private sector labour relations, which is the area that I work, has various functions, including WageLine, which is the telephone advisory service, and also provides internet services. There's online information at the DEMIRS website. We've got summaries of the changes to the state system on there currently, and it also provides information on award summaries and public holidays and the like. And private sector labour relations also has a compliance function, so industrial inspectors are located in private sector labour relations, and they're responsible for enforcing state industrial instruments and laws, and that will include local government. So I think we've moved to panel discussion.
Yes, we have. Thank you, Cara, for all of that technical and insightful information. That brings us to the end of the content of this webinar. I'd like to welcome Davina to join Cara to address the questions that we have been receiving during the webinar. If you could all please use the question function if you have any additional questions, and I'll direct those to the panel. So the first question, Cara, I think it's probably best to direct it through to you. So the question is in relation to public holidays. Do all employers in the federal system have to provide the new Easter Sunday public holiday, including those with an enterprise agreement that does not contemplate that holiday?
So yes, the answer is, and that's by virtue of the National Employment Standards. I think it's section 115 of the Fair Work Act sets out various public holidays, and that includes any additional public holidays that might be legislated or declared in a state or territory. So that means Easter Sunday will be part of the National Employment Standards. And regardless of what your enterprise agreement or modern award might say, the NES are enforceable in their own right. So that's a short answer.
Okay, we've actually got another one. We've got another one with regards to substitution of Easter Sundays to another day, and just to see whether there is that ability for that to occur.
So in the state system, for local governments that are covered by the state system, the amendments to the Public and Bank Holidays Act will prevent substitution in state instruments of Easter Sunday to another day. Most state awards will substitute a weekend public holiday to some day in the week, but the government's intention is that Easter Sunday be celebrated and recognised on the day. So state instruments will not be able to substitute that day. In the federal system, under the NES, there is some capacity for substitution, but my understanding is substitution provisions of the NES have to be basically one-on-one agreement with employees. So if you have a substitution clause in your enterprise agreement or modern award, it doesn't allow for group substitution by majority agreement, for example. Pretty much if somebody doesn't agree to it, then it can't be substituted. So it'd have to be similar to what individual flexibility arrangements are like, where it's one-on-one agreement.
Cara, we've got some background noise happening. Just have a look. So with the next question, sorry, Cara, you're in the hot seat. So this one is, if an enterprise agreement that transitions to the state system has no further claims clause, is there still an obligation to provide terms from the Minimum Conditions of Employment Act that are more favourable?
Yes, again, because it operates like the NES, so it will be implied into your instrument and it will be enforceable as a term of your instrument, and any provision which is less favourable will be of no effect.
Okay, a further query in relation to transitional instruments to Davina to start off with. How do we prepare for changes that may or may not happen?
Thanks, Sam. Look, I think it's quite difficult for local governments at the moment, and we understand, you know, being in this situation is creating some stress and some anxiety in the sector. We can hear a little bit of background noise. I'm not sure where that's coming from. So I think the best advice we can probably give you to prepare is to consider the proposed transition, you know, as part of your general workforce strategies or plans. It's a bit difficult at the moment because while the legislation has passed through Parliament and we'll see those regulations, we need to be mindful that there is still a declaration that we require from the Federal Minister, and our understanding and from our engagement with the Federal Minister is that there has been no decision that's been made at this time, and there's still further consultation to occur on that. I think we're getting a lot of questions generally about enterprise agreements and what to do if you're looking to bargain for an enterprise agreement now or in the near future. So I would probably suggest, if you're already operating in the federal system and you're quite familiar with that, and you sort of already started negotiations or starting soon, that could be something that you just continue with. If you're a small local government, sort of in contrast, and perhaps you don't have much trading activity and you're unsure sort of where you would sit, you do have the option to potentially seek some legal advice, or you can contact us about your specific situation and we can sort of run through what are some of the pros and cons of negotiating in each system, because you will have to get the union on board for those negotiations, and we understand that some of the smaller local governments may not have any union involvement at the moment in their negotiations. In terms of WALGA support for the transition, so we're continuing to develop webinars and fact sheets over the coming months. And when we have our HR forum, the topics will be based around this proposed transition. And we're just focusing really on upskilling the sector and those who work in local government who don't have much experience working in the state system. I think it's really important just to sort of get that foundation knowledge of what are the minimum requirements under the legislation in the state system, and how do those processes work, particularly around bargaining and things like that. If the declaration is endorsed by the Federal Minister, obviously you'll be provided with further support from WALGA to sort of navigate that transition. You've got webinars like today. We did a similar one a couple of years ago on the transitional materials. For subscribers, we've got a number of fact sheets and things. And so that will sort of help you guide through the beginning of that transition period. So it certainly is, you know, a difficult task. We recognise that for local governments. I think the best thing you can do now is sit down and work out, okay, well, what do we have coming up in the next 6 to 12 months, and how can we best plan for those things, whether it be an enterprise agreement negotiation or whether you're reviewing your current contracts of employment, and then working out, okay, how do we best plan for whether this transition goes ahead, and then what do we do if this transition doesn't go ahead.
Thanks very much, Davina. That was a very comprehensive answer. Cara, I wonder if there's any other comments that you would like to make in relation to what local governments could do now to start preparing, given the uncertainty?
Yeah, look, I appreciate it is difficult. I think probably the best thing is just to be familiar with the state legislation and perhaps minimum conditions of employment. So if you are bargaining or looking to incorporate the NES, for example, to make sure whatever is incorporated is compliant with, say, both the NES and the minimum conditions in the state system. And like I said, I mean, the NES is probably more comprehensive, and there are some differences, but not huge differences. So I think that's something that's probably manageable to do. But otherwise, in terms of the timing, if the Federal Minister was to endorse the declaration made, I imagine there would be some lead-in time again before the declaration took effect. It might not be 6 months, but you know, I can't obviously guarantee anything, but I don't think it would be the next day. There would be some lead-in time to give local governments opportunity to ensure compliance.
Thanks, Cara. Now, there's a few more questions that have come up online in relation to transitional instruments. So I'll read them out, and then possibly Cara, start with you, and then Davina, if you have anything additional to add. So the first one we've got is, how will a current federal enterprise agreement and the modern federal award operate concurrently if both are declared state instruments?
Yeah. So I'm assuming you have both instruments applying. If it's a local government, it will be the same as what currently occurs. So I imagine most enterprise agreements deal with the interaction with a modern award, for example. And so you would apply the terms of the agreement principally, and then you have to look to its interaction with the modern award. So yeah, it won't be dissimilar to what occurs currently.
Thanks, Cara. Anything else to add, Davina, to that one?
Yeah, so looking at that question, I think you'll find our transitional fact sheet online quite useful, just to explain how those things work. So it doesn't mean that the federal enterprise agreement and the federal award will become instruments that apply to everyone at the same time. Reiterating what Cara said, your federal enterprise agreement will become a state industrial instrument, and that will continue to apply to those that are covered by the scope of that agreement. And then the modern federal award, becoming that state instrument, will then capture those that are not covered by your enterprise agreement.
We've got another one in relation to transitional instruments, and it is, if the employer was to retire from the industrial agreement and wanted to maintain the current pay rates, which are higher than the applicable state award, then is there anything the employer is required to do to enact this?
No, so provided the contractual arrangements above award, it doesn't require anything specifically. So, for example, there's no IFAs or individual flexibility arrangements in the state system, unlike in the federal system. So provided the, say, rate of pay is higher or there's additional leave entitlements, that's not a problem. Where it does become problematic is if you have all up rates of pay, so you roll into your hourly rate, things such as overtime or allowances and those sorts of things. And then there's a dispute about whether or not that in fact covers those additional entitlements. And so this is something we deal with currently in compliance. There are rules around set off in the state system about whether you can set those things off. And so I would encourage people to maybe consider the case law in the state system around set off before you do those sorts of arrangements. And the main decision is a decision called James Turner Roofing, which is an industrial appeal court decision in the state system, which deals with set off. So basically, I think that decision says if you roll up entitlements and you specifically identify this rolled up entitlement is for A, B, C, D, and you list them, then those entitlements can be applied to those particular things, but not other things, which you may want to bring in at a later date. Or if you don't identify at all what they're for, you may again be able to set it off, but it depends. And I suppose the point is if you're not certain, it's best to get advice on that, because you could find you think you've set off certain entitlements, but in fact you haven't. And so proceedings could be brought against you for enforcement, either by the individual employee or by a union or possibly by an industrial inspector.
Okay, I'll ask you the next one, Davina. It's just in relation to union strategies. Do you know if the unions have any strategies around the transitional provisions?
Thanks, Sam. I think the negotiations that we've assisted local governments with, both the ASU and LGRCU, have in their log of claims that the local government should be negotiating their agreements in the state system and should be submitting their agreements to the WA Commission for approval. This has been happening for a couple of years now, so it's not sort of unusual or new to see this. In our experience, the local governments have been able to explain their reasons for where they want to continue negotiating, be that in the federal system, and I suppose explain why they're not willing to negotiate in the state system at that particular time until there's been some progress with the legislation and the declaration. And in our experience, unions haven't sort of held up bargaining through this particular item in their log of claims. I suppose people are just... I think if unions do hold up negotiations with that log of claim item, I think local governments can highlight that really only delays employees from receiving things like pay increases and things like that, and you can move on to those other matters that you need to finish and bargain with. But if in your local government you've got a specific difficult local encounter with the union on this particular issue, please feel free to contact our team. We can provide some specific advice about that situation. But from our experience, it's been something we've been able to navigate, and it's just about focusing on giving some clear explanations and the local government's reasoning for where they want to negotiate at that particular point in time.
Thanks, Davina. There's another question which is to do with unions as well. And Kara, if you could take this one, please. Do unions with coverage automatically become parties when the local government industry award transition and becomes an industrial agreement?
So no, it's not automatic. There will be capacity for a union to apply to the State Commission to be named as a party to the award or to an enterprise agreement which doesn't have a named party, union party. And the Commission will basically be required to name them as a party if the union has an employee who's eligible to be a member. So there has to be eligibility requirements, and provided that's met, then yes, they'll be named as a party. And being named as a party will then give the union certain rights under that instrument, which includes, for example, enforcement of the instrument and, of course, the ability to retire from the instrument.
And then just on the point of retirement, in relation to the local government industry award becoming an industrial agreement, once the 2-year nominal expiry date is reached, does that give the union the ability to retire from the LGIA? And would that mean that it drops dead? And then does a state award apply?
Yep. So if the union has applied to become a party to that award, or now the industrial agreement, and has been added, then it will have the standing to retire from it. So yes. And then if there's no replacement agreement, then the employees will drop onto an applicable award, depending on the award scope and what the employees do. And they'll be automatically covered by that.
Thanks, Cara. Before I hand over to you, Davina, to close, we've got one more question in relation to engaging with employees. And is there any advice on what we can start letting employees know? If you can answer that one for us, Davina.
Thanks, Sam. And that's a good question. So we have a sector reference group meeting coming up in a few weeks. So there are some local governments that are part of that group, and specific topic we'll be considering is employee engagement. And we'll look at what tools and things we can assist to provide local governments with to start that engagement piece. It is a bit of a tricky issue to explain to employees, I think, because it's quite a technical issue. And, you know, we're okay because we have that, you know, that understanding of employment law and, you know, the industrial situation in both the federal and state system. And for those local government HR staff out there, you've got some good grounding in that. I think the challenge is going to be, how do we simplify that messaging for staff? So that is definitely something we're considering, and we'll roll out some tools to help local governments manage those discussions. In terms of if you're negotiating now, it's probably something that's already come up in your negotiations, so you'll need to start that engagement piece with staff. But really it's just, I think, letting people know this is the state of what's happening now. So it would be that the legislation has passed, that the regulations are now being drafted, but then we still have to wait on that key step of the federal minister endorsing that declaration. And sort of we don't have any certain advice on that at the moment, and that you can update employees as soon as they know. But I think the key thing is letting sort of employees know that this change is not going to have an effect in terms of reducing their entitlements. I think that's quite important for employees to know, that it's not going to sort of impact on people's general employment, and that, you know, there'll be general communication from the local government throughout that whole transition process, because there will need to be sort of flow-on effects. So your policies, you'll need to look at those, your contracts of employment, where things are referring to the federal legislation. If the move does occur, you'll need to be updating those things to refer to the state legislation. So it's definitely a fair bit of work to do in that space. And yeah, we look forward to, you know, working with local governments at that sector reference group meeting, and then developing some templates after that time. Thanks, Sam.
Thanks so much, Davina. I'll ask you to take over control of the PowerPoints now and hand over to you to close the webinar.
Thanks, Sam. So, okay, so before we close for today, I just wanted to say a very big thank you to Cara for presenting at today's webinar. We're very grateful for your support and the support of DMIRS to help provide information to the sector on this important issue. And also a big thanks to Sam for organising this webinar for today. Just wanted to touch base about the WALGA website. So we have updated the website in a couple of different areas to provide some more information for you about the state IR transition. So on the screen, you'll be able to see that there are two sections of the website. So for those sector resources, those are resources that anyone can access on our website, so you don't have to be logged in. And you can, if you click on the Policy and Advocacy tab and then click down to Employee Relations, you'll be able to see resources about the state IR transition. And that includes things like some links to all the bill, the different pieces of legislation, all of the state pieces of legislation you'll need to become familiar with, as well as the awards, and other resources that DMIRS offers. And then in terms of the subscribers and the information they can access, subscriber resources can be accessed through the Services tab. And so if you click on Employee Relations after Services, make sure you're logged into our website, and then you'll be able to find the templates that we have started preparing, all of the monthly bulletins, the webinars and things like that will all be available for access. In terms of the main way that we're sort of communicating changes and updates to the sector, so we've commenced our monthly State IR Bulletin in October last year. So that goes through to people who receive our employee relations alerts on that list. We also publish those online. So if you're not currently receiving the bulletins and you would like to, please just send us an email at employeerelations@wagga.asn.au and we can add you to that communication list. And so just to touch base, a little bit more information just about our team on the screen, plus how to contact us. If you've got any specific questions after today, we'd be happy to talk through them with you and to give you some further guidance. And if you've got any questions, I can see another couple have come through that we haven't had a chance to answer today. We'll be in touch with you individually to address your questions. But thank you, everyone.